Everybody, good evening. My name is Frank Roy. At this time, I'd like to call the meeting to order. Today is Thursday, July 24th, 2025, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. Tonight, I have asked West Hollywood student Vivian Molina-Rory if she would lead us with the land acknowledgement.
We would like to begin by acknowledging that the land on which we gather and that is currently known as the City of West Hollywood is the occupied, unceded, seized territory of the Gabrielino Tongva and the Gabrielino Quiche peoples.
Well done, thank you. And for all those who are able, at this time we're going to do the Pledge of Allegiance, so please stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, and if we could do a roll call.
Commissioner Bass?
He's excused, absent.
Commissioner Copeland?
Present.
Commissioner Perpies? Here. Commissioner McCafferty?
Excused, absent.
Commissioner Topshin?
Here.
Vice Chair Goldman?
Here.
Chair Rory?
Here. Okay, so we have 5 members tonight. That's a quorum. We will move forward with approval of the agenda and give folks a chance to look that over, and then I'll entertain a motion to approve.
Moved.
Okay, moved in second. We'll do a voice vote on this one. All in favor, please say aye.
Aye.
Any opposed? None. That motion carries. And we'll move on to the minutes. Same process. Give everyone a chance to look those over and then entertain a motion to approve.
Chair, just one clarification on the formation of an ad hoc committee. I think, correct me if I'm wrong, you said 6 months length and 3 months for check-in or report.
We did say a 3-month check-in. Is there a specific part of the minutes that you would want to amend? It's on page 6 of the PD, page 6 stamped at the bottom of 969.
Form an ad hoc subcommittee for the length of 6 months, is that what you said? I don't remember for sure.
I do recall we said that it would be with a 3-month return on a status update and then a target completion by 6 months.
Okay, yeah, that would be my amendment.
Okay, so the motion is to approve the minutes with the modification of that item C, adding clarification that it's a 3-month return on status and targeted 6-month completion. Okay, do we have a second on that?
Second. Yeah.
Okay, all in favor?
Aye.
Aye.
Any opposed? Okay, so that motion carries as amended. Great. We get to move on now to public comment. So at this point, this is just general public comment. There'll be an opportunity for public comment on the specific appeals tonight. So I'm not seeing any speakers for that. I think we're okay to proceed. I'm getting the nod. So we can move on to the manager's report. Ms. Avalos, could you take it away?
Good evening, honorable commissioners. On our look-ahead calendar tonight, we have 2 appeals, case D 5011 and D case 4877 CD1. During our August meeting, we'll have 2 appeals, D case 5023 and D 4930R. We'll also have discussion on modification to the security deposit interest accrual calculation. At our August 28th meeting, we'll have another 2 appeals, D case 5015 and D case 5029, and there'll be 2 discussions, one on the increase to the valuation guidelines and the other one about the interest rate on security deposits. That's all.
Are there any questions? No? I had a quick one just for my own edification. The R, I know CD stands for compliance determination, but remind me what the R next to the appeal?
I believe it's a remand. So it's coming
Remand.
back.
Great. Thank you so much. Seeing no other questions for staff at this time, we can move on to the appeal portion of tonight's meeting. And with that, we're going to start with our first appeal, which is Appeal-D5011, and this is the property at 642 North West Knoll Drive, number 205. We're going to hear from our legal counsel first, and then we're going to start the process where the tenant and the landlord can come forward or speak on Zoom and provide their statements. So with that, counsel, if you could lead us in a recap.
Thank you, Chair. Good evening. My name is Kellen Martz, Legal Counsel of the Rent Stabilization Commission. As the Chair said, this is D-5011, property address 642 Northwest Knoll Drive, Unit 205. Tonight, the appeal is filed by the tenants in this matter, and the issue before you is whether there's been a substantial reduction in housing services or maintenance issues that warrants a rent decrease under the city's rent stabilization ordinance and the regulations. The tenants have lived in the property since 2011. The tenants are Rand Getlin and Janina Paleo. Apologies if I mispronounce your names. The tenants are collectively referred to as tenant or tenants in this appeal. The property is owned by Le Chateau at Knoll LLC. The tenants filed for the rent reduction on February 10th, 2025, and the hearing examiner found in their favor on some of their requested items, but not all. The rent reductions amounted to $264 for the tenants and $80 for the other units in the building due to common area issues. Tenants have appealed tonight, contesting that the decision is clearly an error, not supported by the findings or evidence in the record, is an abuse of discretion, and contrary to law. Both of the appeals tonight are very lengthy, so I won't recap everything. I think we had a record of 900 and some pages for the packet. So in the tenant's initial application, they filed a rent reduction request for 18 separate issues. The hearing was held on March 10th, 2025. There was no appearance by the property owner. However, the property owner's attorney submitted a brief with their positions after the fact, which is included in your packet. The tenants appeal 10 issues, and those are, excuse me, I'm going to back up. The items that were found or approved for rent reduction were the unit plumbing issues, $70, presence of mold and mildew, $29, on-site resident manager, $20, leaking windows into the unit, $70, repair or replace the microwave, $15, repaint the common area interior, $35, and trash and debris in the common areas, $25. And again, this is added up to $264 for the tenants and $80 for the other units. The appeal is 5 main issues, but they're broken down into 10 separate issues. And those are plumbing, mold and mildew, security gate, cameras, mailboxes, interior painting, window coverings, drywall damage, trash and debris in common areas, and balcony cracks. And staff believes that and recommends that the commission should affirm on some of these issues and remand on some of the others, and we'll go through those briefly. As to the unit plumbing issue, the parties provided photographs and testimony showing that this is a somewhat common problem for the tenants, but that the landlords have made some attempts at fixing the problem. Staff believes that there is substantial evidence in the record to support the hearing examiner's decision and the valuation. For the mold and mildew, there are 2 areas in the unit where there are issues: the hallway bathroom and the kitchen. Staff believes that there is not substantial evidence in the record to support the decision and recommends a remand. There is evidence that there's mold in the apartment, but we recommend that the hearing examiner should review the evidence to determine if the presence of mildew is a maintenance issue as opposed to the mold, and further whether the presence of either mold or mildew necessitates any more extensive remediation to prevent the moisture buildups. As to the security gate, staff believes there's substantial evidence in the record to support the finding on this matter. There was no rent reduction on this matter. Security cameras, the owner has argued that the security cameras were never an amenity in the first place. And staff recommends, because this was not looked into very closely, that the commission remand to the hearing examiner so that they can produce additional evidence to prove whether the security cameras are an actual housing service and then analyze thereafter. As to the mailboxes, staff recommends that the commission affirm on this issue, believing that the mailboxes were already replaced, and so it's a non-issue. As to the interior painting, staff recommends that the commission affirm on the hearing examiner's decision, which found that there was no additional rent reduction needed, as the tenants are already receiving a rent reduction on this in D-4391. The window coverings is the same issue, that this is already receiving a rent reduction in a prior case, D-4391. For the water intrusion and damage to the drywalls, staff believes that there's substantial evidence in the record that this issue was already resolved prior to the hearing date, and that additional photos submitted are new evidence and can't be considered with the appeal. Common area trash and debris, staff recommends that the commission affirm on this issue that there's substantial evidence in the record to support the rent reduction as to this issue. And lastly, the balcony cracks and structural concerns. This wasn't listed in the initial application checklist, but it was included in the supporting documentation and letters with the application, and it was not addressed by the hearing examiner. So staff recommends that the commission remand on this issue so that they can review the matter in full and make a determination and potential rent reduction. Therefore, staff recommends that the commission affirm in part and remand in part consistent with this staff report. And that concludes my report.
I'm sure there are no questions.
None at all.
Who'd like to go first? Do you want to take a shot, Josh?
It's kind of an odd question. I've never thought about this much in my 47 years of existence, but what's the difference between mildew and mold?
It's the severity, and I can look at the report a little bit more closely and explain it a little bit farther, but that is one of the questions, is to have the hearing examiner look at that, and we talked to, I believe, code enforcement on this, and whether mildew just is not as much of a health hazard where the mold is. And so that's why a lot of city codes require mold to be remediated. They don't speak as much to mildew. And so the request here is for the hearing examiner to look at whether mildew, how it applies under our RSO and regulations.
Thank you.
You're welcome.
No other questions this time? Okay. I guess I wanted to clarify something, because I think that we're going to have a lot of issues potentially talked about. So on the items that there was a rent reduction but are not on appeal tonight, I just wanted to go down the list, and I'm just looking at the 7 items on page 5 of the staff report. It's 16 of 969 on the PDF. But the on-site resident manager, there was a reduction, but that's not being appealed tonight.
Correct.
Is that right?
Correct.
Okay. And the microwave issue is not being appealed tonight. Is that correct?
That is correct.
Okay. Is there an appeal on the common area interior paint, number 6?
There is an appeal on the interior paint, yes.
Okay. And there is an appeal on the trash debris
Yes.
as well. Okay. So it's the microwave and the on-site not at issue on appeal tonight.
That is correct.
Okay. That helps me. All right, so then with that, we're going to move on to the testimony portion. And what we're going to do is we're going to start with the appellant. In this case, it is the tenant, Mr. Getlin. I believe he's going to be with us on Zoom. Is that correct? Okay. So my comments are more general for everyone in the audience, also listening for this appeal and the next. But for you as well, Mr. Getland, you're going to have 5 minutes to speak in total this evening, and you can divide your time. You will get a rebuttal argument after the landlord has their opportunity. So whatever you don't use on the first portion will just automatically get applied to the second. You'll need to start by stating your name and city of residence for the record. And this is for everyone, please, if possible, try to stick to the issues that are germane to our discussion tonight, which is the 10 items on appeal. And that will help us with our deliberations tremendously if we can just focus on those items and not stray into, things that aren't within that ambit. And please also, for the record, do your best to be civil and no personal attacks about any other parties or persons. We're just going to talk about these issues. And did you understand all that? And if so, you can begin your time when you're ready.
Yes, thanks a lot. Good evening, commissioners. My name is Rand Getland, and I'm a tenant at Unit 205, 642 Northwest Knoll in West Hollywood. Tonight, you have an opportunity to decide whether West Hollywood is going to truly protect tenants or if landlords can openly mock and disregard your laws without consequence. This case is about far more than one unit in one building. It's about whether breaking the law in West Hollywood is punished or rewarded. Despite extensive evidence of severe habitability violations, raw sewage backups, toxic mold, dangerous structural issues, and city orders that have been ignored with impunity for years, your hearing officer imposed minimal rent reductions. And this sends a clear message. Breaking the law in our city is significantly cheaper and easier than compliance. For 14 years, our home has suffered continuous raw sewage backups, toxic mold, building-wide security issues, and unrepaired safety hazards like cracked balconies. When we lawfully requested proper licensed mold remediation, our landlord responded not only with refusal, but also with a frivolous eviction lawsuit intended to intimidate, retaliate against, and harass us. That case was dismissed by the Santa Monica court recently because the landlord yet again failed to follow mandatory city rules. And we're not alone. A group of tenants in another of their Los Angeles properties has filed a separate lawsuit alleging a similar pattern of harassment and intimidation. The landlord openly mocks the city authority, stating F the city. What are they going to do?
Sir, I don't mean to
Yes.
cut you off, but I really would like, if you can, to minimize the ad hominem and focus on the issues that are on appeal, if that's possible. I know you have your statement you want to read, but it would be better for our deliberation if you could jump to the part about the issues.
I understand, sir. This is generally all about the issues. It's a pattern of behavior that we're attempting to get addressed. This is kind of the last stop on this process, as I understand, within the city. So I believe that everything that I'm discussing is germane to the issues. However, if you guys feel like you have enough to rule on and aren't interested in hearing me out, I'm happy to stop now and we can move on to whatever questions you have and I'll answer those.
No, you can continue with your time and this won't count against you. I really made those requests at the beginning so we refrain from the personal and ad hominem and just go for the topics. But please continue with your prepared statement, but if you could focus on those items, that would be great.
Sure, and just to clarify, we can go back to the record and kind of look it over, but none of this is outside the scope of the facts in front of us. I mean, none of this, as far as I'm concerned, is ad hominem. So I'm trying to give you a broad picture.
Chair.
And if it's not helpful, I'm happy to cede my time and just answer whatever questions are helpful to you.
Do you mind if what the chair is asking, what we need to focus on tonight is the issues that you have appealed, and this is the legal counsel speaking, on the appeal are all that the commission can consider. And so what the chair is asking and what needs to be spoken to is discuss the plumbing, discuss the mold and mildew, as opposed to lawsuits in court and whatnot. So if we can, that's what the chair is speaking to. So I yield back.
Understood. Again, I'll just note for the record, it's all integrated, and a little bit of a shame that we're not allowed to, or we're asked not to share the totality of what we've been through as tenants. Having said that, I think we've been very clear in the record that all of these issues still exist. We know that there have been code enforcement findings against the landlord. They still have yet to remedy those things, which is why the lawsuits are important, because they've been brought in lieu of actually fixing these issues rather. So I'm happy to answer any questions as mentioned. Most of these issues, if not all of them, still exist, and we're attempting to get those remedied. And unfortunately, working with the city, it's been a little bit tough to find relief here.
Okay, thank you, sir. I'm sure we'll have a few. Do we have any questions at this time? Yeah, we have Commissioner Goldman with a few questions, if you can.
I was just wondering if you could speak to the plumbing issues and just how often that those happen.
Yeah, certainly. They've been persistent for 14 years. So they're happening sometimes daily, certainly weekly, and have been for many, many years. In some scenarios, they will come through and snake the line. It's been made clear to us many times by plumbers and others that this is a systemic issue. And of course, it's much cheaper to ignore fixing these things at a systemic level than to repair them. So they have refused to repair them at a systemic level, which makes them persistent issues that we deal with daily, weekly.
And just for the record, on a general month, about how many times do you think you deal with those issues?
I mean, easily 14, 15 times, easily, and sometimes worse. It's because it backs up in other units. We've spoken to many other tenants in the building, and this is, again, a problem that the vast majority of the people we've talked to in the building are dealing with. There's just these random backups that are more, I don't know, meaningful than your average ones, but on the daily, you're dealing with some kind of low water flow or actual backups.
Okay, thank you.
Okay. Go ahead, Commissioner Topchian.
Yes, good evening, sir. Just a very quick question in regards to the security cameras. Were the security cameras been there all the time when you rented?
You know, we moved in 2011, and I really don't recall exactly what was there when we moved in. I do know that there are signs posted all over the building that say 24/7 live monitoring. I do know that they have advertised for years that we have a secure building. We, of course, have evidence of that. And so this is something that has been, and also interactions with the landlords where they said in relation to break-ins and other things that they were increasing the security around the building. So taken together, these have always been things that we thought worked until we started asking for footage after break-ins and thefts.
So, but yeah, you answered. I just wanted to know if it was there from, you know, the time you moved in or later on they installed the cameras. Okay, thank you.
Seeing no other questions. Oh, good, Commissioner Kerpies.
Thank you. So kind of back to the plumbing issue. So I understand, based on the staff report, that ideally you would like the plumbing to be replaced, new. You're tired of dealing with the issues. I understand that. We're limited in what we can do. And what we can do is put a value on the loss of service. And the hearing examiner agreed with you that there was a loss of service, and they came to a dollar amount of $70, I believe. What is it about that you disagree with? Is that dollar amount too low, too high? What would you like it to be?
Yeah,
and what's your reasoning for it?
Yeah, understood. If you look across the totality of what was awarded to us in the form of a rent reduction, it's nearly uniformly towards the lower end of what is allowable. I think if the laws are intended to deter bad behavior by those who are willing to push, brand, or break the law, then I think you want to, especially in a scenario like this, you guys noted how robust the record is. Like, we have tracked this over 14 years. We have visual evidence. We have documentary evidence. We have every form of
Sorry to
evidence.
interrupt you, but can we go back to, so what would be the value?
Right. Sorry, I was trying to get there. I believe if the laws are intended to deter bad conduct, that in a scenario like this, where no matter what you do within the bounds of what you're allowed to do, it's not going to deter bad conduct. But at a minimum, the city can make a statement by awarding penalties at the top end of the allowable to make it clear that this is the kind of behavior that you guys are going to penalize to the maximum extent possible. And I think that difference would only be $100. So the fact of the matter is it'd probably be irrelevant. It's the same reason why they haven't repaired the windows or other things, because
Thank
the
you. Thank
penalties.
You've answered, I've given you 2 opportunities to answer the question. I haven't quite gotten an answer yet, but I think there's going to be an explanation later on because there's a misunderstanding of what our role is here. Our role is not to deter. Our role is not to, these laws are not in place to deter. Those would be separate laws. Those would be fines, and that's not what we're doing here tonight. So I'll just leave it at that for now, and then we'll continue.
Thank you.
Thank you.
Okay. All right, Mr. Gatlin, thank you so much. You're going to have another chance to speak after the landlord. And so at this time, I'm going to call Mr. Zada, I believe, is going to be the landlord representative. Sir, if you could come forward and then go ahead and introduce yourself. And same request as before, please try to stick on topic, and please state your name and city of residence. And you have just 1 opportunity to speak, so you get 5 minutes. Okay.
Good evening. Thank you, everyone, for your time today. My name is Jacob Zeta. I am a resident of Los Angeles City. I'm the attorney for the landlord, and I'm happy to answer any questions as for today. First of all, I appreciate everyone's time. I will try my best to keep it short and concise as to the points of the report. The first point I want to make is as to the common areas. With respect to the common areas, the landlord made all of the necessary repairs within 3 days of the findings and promptly submitted a compliance determination form with all the required documentation and photos with the Rent Stabilization Department. The landlord intends to fully comply with the findings related to the Getland unit, pending resolution of any ongoing legal matters as to anything else. But as the common areas, the certificate of compliance was filed with the city. Now, as to the rest of the report, our position is only as to 3 of the issues. We're not challenging the remaining of the report. The first point I would like to bring up is the mold and mildew, which I know is a high point of contention between the parties. First of all, I do like to make to the point that the report did state that the granting of the 29 reduction is already on the high range. So the tenant is already receiving one of the best rent reductions he could receive as to that. Furthermore, the report also indicates that the mildew would be a tenant requirement, not a landlord requirement. So that's something that the board should take into consideration. Also, after the examiner carefully reviewed both the landlord's mold consultant report and Mr. Getlin's report, the distinction between the mold and the mildew was accurate and legally sounding. This reflected the balance of the assessment of the evidence. Per Health Codes and Safety Code section 17920.3, only dampness or visible substantial mold constitutes a substantial condition. Mold is typically a surface cleaning issue. It's not a structural defect or health hazard requiring extensive remediation. While we disagree with certain aspects of Mr. Getlin's report, the landlord accepted the ruling in its full. The evaluation was thorough and reasoned. Remanding the issue would be unnecessary and could set a precedent for revisiting settled finding issues without new evidence. I think the board should, again, take into consideration the fact that there was already a substantial investigation regarding this issue, and the tenant was, again, awarded the high end as to that. And again, the report does indicate that the mildew would be a tenant issue, not a landlord issue. The next thing that the landlord is contesting is the cameras. As asked currently of the tenant of whether the security cameras were a service provided in the beginning, he couldn't answer that question because the truth is it wasn't. It was never a service provided. The landlord did post cameras post pictures of warning cameras throughout the property to deter people from, stealing. I have one in front of my house. I put a ADT security camera thing. I don't really have one, but I put it there to try to deter crime, and that's just a benefit for everybody. But there was never an actual camera system. It was never a condition of the lease agreement. If you look at the lease agreement, it was never a bargain for exchange as to consideration for the tenant having a service at the property. Remanding this issue wouldn't be necessary because there should be at least some factual finding by the tenant for the board to consider prior to remanding this issue of, some showing that this even could be a service. But it's clear from the lease agreement it was never a service, and there was no evidence presented in the record that this was a service to begin with. As to the balcony and cracks, I think one important point is to consider that that was never a part of the original report made by the tenant. That was only brought up later on. And the landlord is currently proactively looking into this issue. We do believe that this issue might have been possibly caused by the tenant due to things that are currently on the property. And that's something that can be considered as well because there are heavy pots and plants that are placed on the balcony that are the cause of this damage. However, we are willing to work with the board and with the housing department to have that issue corrected. Just like to bring up per Civil Code section 1929 and 1941, if the tenant's conduct contributed to the damage, reducing rent prematurely would be inequitable before responsibility is fully determined. The examiner's decision appropriately balanced this without assuming fault.
That's your time.
Okay, thank you, Mr. Zeta.
Thank
Appreciate
you.
your time. We'll see if there are any questions from the commission.
And just as a side note, I do have the property manager here for questions of repairs, so we may, some questions he may answer better than I can.
Okay. Go ahead.
Just
Commissioner Chan.
good evening, Mr. Zeta. Just a quick one. No representative for the owner was present at the hearing. Is that correct?
I am the representative for the owner today.
Well, you were not at this appeal hearing, but at the original hearing with the hearing examiner, there was no one.
Yes, and I apologize for that. That was my issue of the scheduling conflict, and we
No,
submitted
that's
it.
fine. I just
Yeah.
wanted to ask you the following question. So the record was kept open by the hearing examiner, or it was reopened to allow to submit evidence, etc. So were you able to provide at that time when the record was open,
Yes.
whatever you needed necessary?
Yes.
Okay, thank you. Oh, Chair, if I may.
Please.
In the question regarding security cameras, which I take seriously, anything that has to do with the security in our city, right? So, from your statement, I understood that there were no security cameras ever installed anywhere on the premises.
Correct.
It was just the sign.
Correct.
Okay, all right, thank you.
No other questions?
Make sure we all understood that. So you're saying that there are no physical security cameras. I'm not saying whether they're operational or not, but there are no physical security cameras on the premises.
Correct.
And never were during these tenancies.
Correct.
Thank you.
No, I think you confused me. You're saying there are cameras, they just don't operate. They're for show.
My understanding is that there was never any operating camera system at all.
Right.
The landlord may have put signs of a camera system, but there have never been operating cameras.
What about just cameras themselves? We'll have you check on that?
We're
Okay,
checking on that right now to see if
Okay.
there's any even.
great. And this would be what we want to know what you submitted to the hearing examiner on that issue, which I assume there's either actual cameras or there aren't. We understand they're not operating.
But I also like to make the point that I don't think the tenant can make a showing that there was even cameras when his tenancy began. So I think it's important for the board to consider, was this a service at the time of signing the lease in consideration for the rent that he's receiving? So if he's claiming a reduction in rent For example, if let's say the landlord added the cameras later on, right, during the tenancy, the board should consider, well, okay, at the time when he signed the lease, let's say it's 2015, at that time there was no cameras. If there's an additional service added later on, then the tenant is not entitled to a reduction of rent because at the time when he signed the lease, that wasn't a service he bargained for.
I'm not sure that's right.
We
I think
can-
services can be added during the tenancy, and if they were and they were operational, that's a different matter. But anyways,
As to the cameras, we did get a response.
There are physical cameras, but they were installed after he moved in much many years later.
okay, so for everyone's, because they can't hear you at home, please speak into the mic and say that.
There are physical cameras at the property, but they were added on much later after he moved in.
Okay, and they do not operate.
No, I don't believe so. But there are physical cameras.
Okay. That's,
But we also never made the representation to the tenant that they do operate.
I understand. Commissioner Copeland, Commissioner Topshin wants to finish, and then Commissioner Copeland.
Just very quickly to wrap it up, I mean, for me at least. So the devices, a security camera devices were installed physically on the property, on the premises. And there were signage also posted that there are cameras operating, performing, surveillance performing 24/7. Is that correct?
Correct, and they are now operational.
Right, but what I'm saying is there is no dispute that the actual devices were installed on the premises?
There are physical cameras on the property currently, and they are operational.
Okay, all right. Thank you.
All right, Commissioner Copeland?
I think Commissioner Topkin's question clarified some of it for me because first there were just stickers, there were no cameras, then there are cameras, but there was testimony in the record by the tenants that they were given the impression the cameras did work, but that the respondent declined to share the video images with them when there was some theft or something that had occurred. So I just wanted to be sure that were these at any time operational, the physical
I
cameras?
apologize for misstating. So I did clarify, they are currently operational at the property.
They are operational. Are we obligated to give footage to tenants?
Okay, thank you. That's all for me, Chair.
So that's kind of a significant development here legally, and we've gone now a couple different directions. Are you saying that currently at the property there are operational cameras?
That's what I'm told, yes.
Say that into the
He
microphone,
said,
please.
yes, that is what we're told, yes.
Yes.
Okay. Well, and that was the information that was provided to the hearing examiner?
I'm not sure.
Okay. Okay. I'd like to ask real quick on the plumbing issue, just the plumbing issue. Real quick, what's your response to the tenant's testimony about how frequently the plumbing is backing up?
I think it's an exaggeration of 15 times per month. There's no notice given to the landlord 15 times a month that there's an issue with plumbing.
Not that I know of, no. We have
Okay.
work order records since we took over as management, and there's very little plumbing issues as far as my
Okay.
knowledge.
All right, thank you, gentlemen. You can go ahead and sit down.
Thank you.
And Mr. Getlin, it's going to be your turn again, and I'm going to ask our clerk, Madam Clerk, if you could remind him of what his total time was, and please don't count the time when I was chatting with him or when council was talking.
You have 2 minutes and 55 seconds remaining.
Okay, so almost 3 minutes, Mr. Getlin. The floor is yours.
Thanks. I think, I probably don't need the totality of this time, and it does sound like perhaps I misunderstood the function of this commission. Listening to the questions that you're asking the landlord helps me a little bit better lock in on what you guys are looking at. I would say as it relates to the plumbing, just to be very clear, if you look at the record, there's a very robust record dating all the way back to 2011 through 14, I believe, where we began noting the persistence of these plumbing issues. We have since collected evidence of persistent plumbing issues in other people's units. I know that's not the purpose of this conversation, but the point is, the reason why we don't reach out to the landlords anymore is because they do act in punitive ways when we ask for repairs that they're legally obligated to make. That's the point I was trying to make earlier with my statement. We've been dealing with this for 14 years. We're simple folks. It's my wife and I and our little dog, and all we want to do is live a peaceful life. We're not asking to live in a palace. We're just asking for them to make repairs that they're legally obligated to make. And instead, we deal with retaliation and harassment and various other forms of attempting to make our lives difficult. And it's effective. They're very effective at making our life difficult. I mean, we don't want to be here doing this right now. There's a lot of other stuff we'd rather be doing with our time, but here we are and we feel forced into this situation. And so to the extent that the commission has the ability to provide tenants with relief, however you guys most precisely define that, that's what we're here seeking, maximum relief so that we can live a peaceful existence. And that's it.
All right, that's great. We do have one follow-up question, Mr. Gallen. If you could hang on, Commissioner Kerpes has a question.
Thank you. It's regarding the mold and the mildew. It's my understanding, based upon the record, and you can confirm this for me or maybe correct me, that there were multiple locations within the apartment that contained mold or mildew. Is that correct? I believe there was, my recollection is there was 3, but
Recording stopped.
Can you clarify that and speak on that?
Sure. It's I'm not a mold expert, and if you guys looked at that mold report that we had commissioned at pretty meaningful expense to us, you know, it's very comprehensive, and I think what it lays out, in addition to the verified toxic mold spores that exist in the kitchen, is heightened moisture above 20% in the walls, mildew from appearance on the outside, and I don't think that we had them do a hole punch in the bathroom, so it's very possible that mold is growing behind the walls. But they provided remediation recommendations, and the landlord still to this day has not fixed these things, either of them.
I guess, I don't mean to cut you off. I guess what I'm trying to figure out is, remind me, was it 3 locations in the apartment that, whether it be mold or mildew? I'm just combining the 2 issues
Yeah,
right
I understand.
now.
Sorry about that. Yeah, so in the master bathroom, it exists, but I think that's where it's being debated whether it's mold or mildew in the walls, and then in the kitchen, definitively. And then because the tests are expensive, and this is important to note because this impacts all kind of tenants in the jurisdiction, it's expensive. It was, I think, around $1,000 to get the areas of the apartment tested that we did. And I'm not sure that a lot of people living in rent-controlled units are going to be able to just
So what I hear you,
pay that.
What I hear you telling me is there are 2 locations in the apartment that mold or mildew that existed. The master bedroom and the kitchen.
It's in the kitchen and the master bedroom bathroom, correct? But just want to make sure that clarified. Yeah, definitively, because we could have tested further, but because it was expensive, we did not test all around the unit.
Thank you.
Okay, thank you so much, sir. We appreciate you speaking. I'm going to close your portion of the testimony this evening, but please stick around. We're going to deliberate now and make our decision. I think I skipped public comment on this particular appeal, but I don't believe we had any. So that, just for the record, testimony portion is now over. We can begin the question and deliberation portion. I have a suggestion on this for my fellow commissioners because there's like so many issues. My thought was, let's go issue by issue and just kind of talk about what our thoughts were on that issue, and then I can try to cobble together consensus on like we agree mostly or there's different thoughts versus each one of us going down the whole litany, and that's hard for me to mentally keep track of. So are you okay with that? All right, I'm hearing nods. So I'm going to start with the plumbing issues, and we can open it up too if people have questions from staff and things like that too. But on the plumbing issues, my understanding is the issue basically before us is whether there's substantial evidence to support the $70 rent reduction, whether we think it should be more. I had a question about what the potential guideline could be on the plumbing issue itself. But I think on this one, we're deciding whether $70 is supported by substantial evidence or whether people think it could be more.
Can I, Chair, can I ask, I don't have the with me the full packet. What is the what are the ranges? 30 to 85. Okay. 30 to $30 to 80 to 85.
30 to 285,
Yeah.
Commissioner Copeland. We'll have council confirm that. I can see he's doing that.
Okay.
That is correct. There's 5 different categories for plumbing. Toilet is 30 to 285.
Okay. All right, so 70 is not even halfway of 285. Right? I mean, 285,
Yeah,
140 would be halfway.
Yeah, but yeah, I see the point.
I'm giving you my thoughts on it as I narrate it. I mean, that seems kind of low to me, but I don't know if other people
No,
have a thought on whether we would adjust the 70 or recommend adjusting the 70. Go ahead, Commissioner Coleman. Vice Chair Coleman.
They're also saying it's not just one toilet, so I'm thinking there are sinks, it seems like it is kind of lots of different fixtures going on, so to me, 70 feels on the low end if you're not talking about one fixture, but multiple fixtures.
Okay. On this particular issue, Commissioner Kirby's, what do you think?
Yeah, I would say that I'm not opposed to reevaluating the dollar amount and increasing it because based upon the hearing examiner's decision, they don't really provide much analysis. I mean, he takes into consideration several issues, but doesn't provide any real analysis in my view of why he came with the 70. He just establishes the 70. So I'm okay with if the council or if the commission wants to adjust it, I'm okay with that.
Commissioner Copeland?
I agree. I'm looking at the photos and that there are multiple issues going on with the plumbing here. It seems particularly egregious to be on the low end of that, and it's been ongoing, and talking about sinks and toilets and sewage and so forth. So I think, as you said, even the mid-range was 140, 250, and this is certainly at the lower end of that. So I would be amenable to a higher amount on the plumbing.
Okay. All right, then on that, let's move on to the next item, which is the mold and mildew. This one, the way I see it is staff is recommending that we remand on this because of the discrepancy between mold/mildew. I'm inclined to have that sussed out by a hearing examiner. I do know from my own personal experience, mold and mildew can be very different things. It would be helpful to me to have the hearing examiner really look at that particular issue, make a further clarification on it as recommended. I did have one question on that range, 29. Is that on the higher end? I think we heard tonight that might already be on the higher end, but what's the range for mold, the number 2 item?
It'll take me a moment.
Okay.
I'll get right back to you though. 7 to, well, so the hearing examiner in this, there is not a mold and mildew category established, and so the closest was plumbing, sink, bathtub surfaces. And that was 7 to 29.
So 29 was the higher. Okay, so we couldn't even go higher. We could just remand to clarify the issues that staff recommends. Commissioner Kirby's, what are your thoughts on the staff recommendation for this issue?
I agree that we should remand it. There's too many issues, too many complex issues that need to still be sussed out to determine whether that was the right amount. Do we have any recommendation, though, on a better, I don't have the list in front of me, but is there a better comparison than sink and bathtub? And hopefully the committee will look at this in the future, mold, because mold is a common issue that comes up. So I'm surprised we don't have something to compare it to. But if we did have something to compare it to, then maybe we could give some direction on that. But if we don't,
That seems like it'd be good. I don't want to get off topic, but for the ad hoc.
that's what I mean, yeah,
Right.
separately, but still to give direction that if there is a better comparison, the hearing examiner should make sure that they're using the right comparison on the list.
Yeah. Any other thoughts on this one? Okay. I'm seeing, so then the next item was excuse me, I lost my place here. The repairs to the security gate and security cameras. And this one had a couple of sub-issues, so I want to be careful that we're talking about security gate, security cameras, and mailboxes. And on this one, there was no reduction for the security cameras because the hearing examiner was under the impression that they were never operational, I believe, but tonight we're hearing that perhaps they are operational. Frankly, I was a little surprised at how fluid the discussion was on the cameras, and that definitely stuck out to me as something I think maybe the hearing examiner needs to really dig into in light of some of the testimony from this evening. On the security gate, this one, there was no award for the security gate, right? No reduction, and there was no reduction for the mailboxes because it looks like something had been installed. So I guess I'm kind of leaning towards following the recommendation on those items as well, just because we didn't hear too much specifically about those tonight being any different from what the hearing examiner already looked at, but the cameras seemed like there was something else happening.
I think that
Chair.
I was just going to say that I think that the hearing examiner actually did receive the same information we received tonight in terms of the question of whether the security cameras, when they were operational, when they weren't. I think that he concluded that they were operational now, but what was unknown was whether they were ever non-operational because they never provided, the tenants never actually got to see any footage from it. So there was the only thing that he had in front of him was that they were operational. And I agree with you that I think that we should just stick with the recommendation of staff tonight. But I think maybe council, can you clarify just so it's out in the open that there was some statements made tonight about that if a service is provided later in the tenancy that it doesn't matter if you take it away. Can you clarify that? Because I think that's incorrect.
Yes. It's fact specific. It's not a black and white rule. So if they put a pool in and people start using it, that's a service provided. But the camera issue, which is why we're recommending remand, is was that a service even provided to the tenants if they're not getting the benefit of it at all? They never got the tapes. And so that wasn't fleshed out well enough in staff's mind for us to look at that. And so that's why. But to answer the question, a housing service generally is there from the beginning, but you could add one later. It doesn't mean that that tenant gets it under our rules. We would have to look at the specific facts of each housing service.
If the cameras, I guess maybe, and I appreciate your clarification, so potentially if during the entire tenancies the cameras were never operational, but now they are, the idea is somehow there wasn't a service provided during the tenancy or up to the point of the rent reduction because they weren't operational. There's a psychological benefit to having operational cameras. And if there's an actual functioning camera there, I was thinking, this is maybe for the benefit of the hearing examiner, that these were faux cameras. That was kind of what was suggested tonight. And then I could see that there was never a service that could be provided because they weren't real to begin with. But if there were real cameras there and they weren't operational, there's a service in having cameras that I don't know, there might be a psychological benefit there that is a service that's related to the operation. So I hope that gets considered on remand as well, because it sounds like they could have been operating that whole time, and maybe folks were led to believe they were operating that whole time, and whether tapes were provided or not, there's still that benefit of knowing, oh, there's an operational camera here. That's going to be good for my safety. So I think they should look into that. But go ahead. Does anyone else have thoughts on this one?
Yeah, Chair. First, a question. We're remanding the security cameras only, right? As I understood, security gate and mailboxes will not be remanded. So, and I appreciate the explanation by the council in terms of whether the security cameras would constitute housing service provided by the landlord. So obviously, if it goes back before the examiner that can look into that, and based on the information received that that this was not, the cameras were not there since 2011, or when the date was the tenancy started. So they're going to look, the examiner will look into that. But what is the purpose of installing a camera if the camera is not going to work? So what's the purpose of it? So if you are installing a security camera, that means you're adding a service to the tenancy. So if you're adding a service, the expectation is that the service must be operable, must be operational. So I think that's the logics behind it. Otherwise, just don't install the camera. So don't add something that is not going to properly function or operate. So I'm in full agreement to remand this issue, especially when we see that, when we heard the statements, the cameras were not there, or they were there, but they were not operable, and now they're fully functioning. So what is it? So we need to know, and I think the examiner will be able to find out, get the answer to that question. Thank you.
Go ahead, Commissioner Copeland.
Oh, thank you, Chair. Yeah, I agree with Commissioner Topchin that this is something that should be remanded to the hearing examiner to consider, make the determination, was this a housing service, which testimony appears that it may very well have been, but that's up to the examiner to determine. And also, as Commissioner Topchin mentioned, if you have advertising that this building is secure and the tenants are seeing cameras going up, there is the assumption that this is a security and a quality of life safety issue that you have a benefit of, so I think that determination needs to be made, whether that's true or it's not true, for the benefit of the tenants and for the record. So I agree with the remand on the security cameras. Thank you, Chair.
And Vice Chair.
Yeah, I agree with the remand as well for the reasons that all my colleagues have stated.
Chair, one more question.
Please.
You mentioned, and it's been mentioned here, so about the footage or the tapes. I'm not sure if the giving copies of the tapes or the footage to the tenant, I think that should be a part of the review. I think all we need to ask the examiner to look into whether the examiners are functioning. I don't believe anything that shows here, and based on what we heard, there was an obligation or there was a service by the landlord to the tenant to provide the actual copy of the tapes, of the footage. So I just want to make sure if we're on the same page, or...
I would ask council to weigh in on whether we're within the purview of evaluating whether a landlord has a duty to provide tapes. To me, that seems like outside the scope, but tell me.
It would be outside the scope.
Okay.
Yeah.
Thank you. Thank you.
Okay. So then let's move on to the next item, which was the water intrusion and damage to drywall. And on this issue, is this the one that goes for interior painting window coverings, water intrusion, oh, and damage to drywall, I'm saying down here. The staff recommendation is that it was resolved prior to the dispute. And yeah. So what are the issues under that particular, does it also include the interior painting and window covering recommendations? Are we talking about all three of those right now?
So the interior paint and the window coverings, staff recommends affirming the hearing examiner's decision. Those were already decided in a prior case. And so
Right.
there's two issues, interior paint and
Right.
window coverings, and then drywall damage, affirm as already resolved.
Okay. And so there was no reduction on the drywall because it was affirmed as already resolved. Is that correct?
That is correct.
Okay. I didn't hear anything tonight about drywall specifically that would change my thinking on whether we should agree with staff on this particular issue of the drywall. I agree with following staff's recommendation on window coverings and interior painting because they're covered by a prior finding.
Yeah, I think the only question about the drywall, which is not a question to me, but I think the question was that they submitted evidence after the decision was made that shows that it was not, but that is handled separately. So I would recommend that the tenants seek another path for that if they feel that it was not or has not been fixed. But according to the evidence, the drywall has been addressed. That's my understanding of what I read.
Correct summary.
Just taking a note here real fast. Okay, and then so the last group of issues is the trash debris. I'm sorry, the balcony cracks. Balcony cracks. So that is, we heard a little bit about that this evening, but the recommendation on the balcony cracks is to remand to have the hearing examiner review it in full. I'm not opposed to that, adopting staff's recommendation on balcony cracks. Does anyone have a different thought on that one? Yes, I would be supporting the staff recommendation to remand this issue.
Yeah, I agree.
To make a better decision about it. And we did hear some testimony tonight that there was willingness, which I appreciated hearing, to address this issue. So I hope that continues as well. But on balcony cracks, what are people's viewpoints?
I think I agree with staff's recommendation to remand, since I don't have any other information to go off of other than that. I mean,
Vice Chair?
I support the remand as well.
Okay. And then, so the only other one I don't know if I covered was trash. Oh, sorry, Commissioner Copeland?
No, I just had a question for council, actually, if that's possible, with regard to the balcony cracks. I agree with the remand, by the way, but I was just curious if, as part of that review by the hearing examiner, in a case like this, when you have a structural question and hasn't been a determination made of what's causing it, can the examiner request any sort of code or building and safety inspection as part of that? Or is that has to be a whole separate issue?
I'm looking to our manager here to
Okay.
assist on what the normal process is. I know we can send out our RSD department inspectors, but I don't know
Okay.
if they call in code.
So that would be the normal procedure that we just send out?
It wouldn't be the examiner that would refer them to code. Normally, if a tenant comes to our front counter and asks that they're filing for a hearing, we will educate them on, based on what we see on the list of issues, we will say, these are issues that code enforcement can also address, and they can do an inspection. So it would probably come from staff and not necessarily a hearing
So
examiner.
not as part of a remand or from the hearing examiner?
That's
Okay.
correct.
Thank you. Appreciate it. That's all from you, Chair. Thank you.
Thank you. Commissioner Topchin? Any further thoughts on this one?
No, I said it, I agree.
Okay. All right, so then let's move on to the last area. I think, please chime in if I missed one, but it's common area trash and debris. And that's on our list of issues to talk about. There was a rent reduction on this of $25. Staff is recommending that we affirm. I have a question on the range for this one. Was 25, where did that stand? And oh, I see, it could have been 24 to 64, and they adopted 25. Okay. I think I'll let the fellow commissioners chime in here, but this one I might be in favor of adjusting as well. We didn't hear as much specific topic on this, but there were quite a few pictures in the packet that were submitted that would suggest this was still an issue. So if other commissioners were amenable, I might be willing to modify this amount.
Chair, what are the ranges?
24 to 65. Wait,
64.
Is that 24 to 64, which is for gardening, landscaping?
Thank you.
That is correct.
And tenants are asking to increase 50 to 64 to deter repeated
Right.
neglect.
Now, the point about deterrence is really well taken, and I'm so glad you brought that up. This is to compensate a loss of a service. So it's a different legal standard of harm. It's a different way of thinking about damages. Punitive damages are things you do to prevent and deter conduct. These are reduction in service damages. So you just look at how much is the service and what's the value of that, and we're not looking at the punishment deterrence part of this. But even with that clarification, I think 25 out of 24 seems low. I might be willing to adjust that, to something closer to 50. That was my thought, but
Can I go?
Commissioner Kirby's, yes.
Yeah, I would say that on this one, I think we've done a really good job throughout this discussion, kind of justifying where we're at on various issues and deferring mostly to the hearing examiner and deferring to staff when they've made points about remanding back to the hearing examiner. On this one, I just don't see where we have other than our own personal opinions about our judgment on the pictures, I don't see arguments for why, and nor do I see, or any new evidence, or I'm sorry, any evidence that the hearing examiner didn't review already and come up with this conclusion. So I think just, unless we have some other evidence that was missed, I think we just got to stick with the hearing examiner.
I appreciate that comment. Commissioner Copeland, I see you thumbing to some pictures. Maybe you would like to tell us what you're looking at?
I was just looking again at the pictures of the debris and so forth. A lot of it seems to be like construction related or things that, on pathways and so forth. If we look, now that I've changed the page, like on page 191 of our packet.
I'm really sorry, sir, but we can't have any more comment. And to be fair to both sides, you have to just let us do our deliberation.
I was just looking at that in order to review as I was listening
Yeah, no, I
to
appreciate it.
comments.
I'm looking, Commissioner Topshin, do you want to weigh in on this one? The issue, are you?
So, Commissioner Copeland, you were saying you would agree to remand this, or you would agree with the?
No, I was talking about the change in valuation, based on what the fellow commissioners were saying. So I just wanted to review the photos to get another review of whether that amount was as low as it appears to be. So I wouldn't be opposed to an increase in that by some amount.
Since we're going to look into the change in the value of the plumbing matter, so I'm willing to also look into the value of the trash and debris as well.
Okay. Vice Chair, what are your thoughts? Adopting and keeping the range where it is, or potentially modifying the range?
I'm inclined to potentially modify the range, but I'm also wondering, and I can't remember from my reading of it, did the hearing examiner give a reason for that valuation? I know sometimes they do, sometimes they don't.
They did. They stated that there was an attempt by the landlord to attempt to keep the debris stored in a manner as neat as possible. However, even neatly arranged items may constitute a violation of our maintenance standards. So that was their explanation.
Interesting. So it was fine that the debris was there, I guess, according to the hearing examiner. That wasn't the issue. And okay, that helps clarify. Thank you.
Okay, well then, I think those are the issues. So if I'm gonna circle this all up, it sounds like there's potential, sounds like for the most part, we're gonna adopt staff's recommendation to remand on mold, to remand on the cameras, to adopt the recommendation on the water intrusion, adopt the recommendation on interior paint, adopt on the window covering. We agree to remand on balcony. And the only two areas were plumbing and trash debris, and whether we might modify those, the staff recommendation. Let's circle to plumbing and whether, I mean, I guess we could just do my thought was maybe we could suggest midpoints, 140 on plumbing, 50 on trash debris. This is the part where I think those are mid-ranges. There's clearly was a loss of service on those issues. If it's been resolved, great. That's what a compliance determination is for. There can be a restoration, an adjustment to those rent reduction amounts. But I think on the record here, and not for punishment purposes, just what we're talking about was a loss. Both of those being on the low end, I'm comfortable moving to the mid-range. So 50 on trash debris and 140 on plumbing. And I appreciate Commissioner Kirby's comments about deferring to the discretion of the hearing examiner. And I normally find myself in that camp, I really do. I think tonight, though, I'm comfortable with going with a modification on these facts.
I'm satisfied with the figures that you mentioned, 140 for the plumbing and 50 for the trash and debris. And thank you, Chair, for mentioning that these are not punitive charges. These are to compensate. This is what we believe would be the reasonable value of the loss of the service. And these fees do not constitute penalties. Just wanted to state on the record. Thank you.
Commissioner Kirby's.
Yes, and I still am opposed to the individual item of the common area, but it's not going to prevent me from supporting a motion that carries all of that in it, because I personally would have actually went higher for the plumbing. So it kind of, in my mind, the math washes out. But there are two separate issues. But yeah, I will support the item if it's moved in containing the discussion or containing the points that you just made.
Okay. Vice Chair?
I'm comfortable with those amounts that were proposed, so I'm prepared to support that.
Okay. All right, well, with that then, I would like to make a motion to adopt and modify resolution number 25-690, a resolution of the Rent Stabilization Commission of the City of West Hollywood regarding this Knoll property. And the motion is to adopt the resolution as proposed in full and to modify just the rent reduction for the plumbing to increase it from 70 to 140 and to modify the reduction for the trash and debris so that that is increased to 50. So,
And Chair, before you make a vote on that, there are the factors that we have to say why we are changing that. And there's the extent to which the reduction in services affect the tenants. I believe that one. The impact on the habitability of the unit and the market value of the housing service in question. Would those all apply?
yes.
Okay, I will use those three then in the resolution if it passes.
Okay. So that is that's the motion as proposed. Do I have a second?
I'll second.
Okay, we have a motion and a second. This one we will do a roll call vote.
Commissioner Copeland,
Aye.
Commissioner Kirby,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Goldman,
Aye.
Chair Rory.
Aye. Okay, great. So with that, that motion carries. And I would like to read my statement here for the record, which is the motion passes. So if the parties have any further questions, they can reach out to the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. And Mr. Getlin, thank you for your time on Zoom. You'll now be placed back into the waiting room. And if you'd like to watch the rest of the meeting, you're welcome to do so. And you can refer to that at weho.org/WehoTV. I'll get more smooth as we go along with this. I appreciate that time. We're going to do a quick recess before our next appeal, about 5-10 minutes or so. So with that, we're in recess. Thank you. Okay, thank you, everyone. We're going to now resume our meeting, and we're going to continue on with the next item on the agenda, which is application number D-4877CD1, and this is concerning the property at Larrabee. And it's going to be the same process as before. We're going to have the appellant come forward. They'll have an opportunity to speak, and then the respondent, and then the appellant goes again. We are also going to do public speaking on this topic. I know there's a few requests, and I wanted to clarify, I do that when exactly do I do that? In between, or can we do it at the beginning? Tell me where it goes.
Typically, it goes after the appellant speaks the
Okay.
first time.
Okay, so we do have at least two. If anyone else wants to speak on that, just go ahead and let the clerk know. And we start the process, of course, with a report from legal counsel, and we'll take it from there.
Great, thank you, Chair. Again, my name is Kellen Martz, legal counsel to the Rent Stabilization Commission. As the Chair noted, this is application number D-4877CD1. CD stands for compliance determination. Property address 917 Larrabee Street, unit number 6. However, all the issues tonight are common area issues. This appeal has been filed by the landlord tonight. This has been before you once before, and the compliance determination in this case, the decision was issued on November 14th, 2024. The 4 issues before you tonight, as noted, are all common area issues. Those are the washer and dryers, mold in common areas, plants and bugs or insects, and storage in the garage. Staff is recommending that the Commission affirm the hearing examiner's compliance determination in full. And I will defer to the staff report for the background on this, as you have already been through this before. However, just shortly, the washers and dryers that there are, the tenant previously has testified that there were 3 washers and dryers, none of which worked at the time of the original hearing. Neighboring tenants also confirmed these issues. As to the mold, the tenant originally testified that there were roof leaks and those hadn't been fixed in the common areas, causing mold. For the plants and bugs, the tenant originally testified that the gardeners don't maintain the plants, resulting in roaches, termites, water, mosquitoes, et cetera, et cetera. A neighboring tenant stated that the plants were not maintained by management and that there were rats. And then the storage issue, tenants and others, neighbors testified that there were items stored in the garage and around the property in a haphazard manner. Items included couch, walker, crutches, shelves, and other random items. There was an original decision issued on July 10th, 2024, which granted a rent decrease for 13 issues. The landlord filed an appeal on July 23rd, 2024. The Commission upheld the original decision in RSC Resolution number 24-660. The landlord then filed a compliance determination request, and then a decision on that was issued on April 24th, 2025, which is the appeal that is before you tonight. And the landlord has argued on appeal that the determination is in error, is not supported by the findings or evidence in the record, that it is an abuse of discretion, and that it is contrary to law. And again, the issues on appeal are washer and dryers, mold in common areas, plants and bugs or insects, and storage in the garage. As to the washers and dryers, the landlord argues that the requirement is impossible to meet and that the city is requiring more than what is required under the city's code. Here, the landlord cites to West Hollywood Municipal Code section 1756.010 subsection B that all appliances have to be maintained in good working order. That's our maintenance standard. And the landlord believes that they have met that standard. However, this item was looked at as a housing service, not just a maintenance standard. And so the original decision found that the washers and dryers were poorly working, and so it is both a maintenance issue and a housing service issue. And so staff believes that there is substantial in the record to support the compliance determination decision that the items are still not in good working condition and is a housing service that was taken away. For mold in the common areas and the bugs, the landlord appeal focuses mostly on the city's inspection of the property. There was an inspection report. The landlord's appeal also takes issue with the fact that the hearing examiner did not restore the rent on the issue, even though they believe that the inspection report was a favorable decision in their eyes. However, one, the hearing examiner is the final arbiter of that and does not have to consider the inspection results. They just use that as a tool to guide them. Our regulation 60014 says the hearing officer may consider the results. It does not require them to do so. So even if the landlord believes that the inspection was in their favor, the ultimate decision is made by the hearing examiner, and who found that that issue was still ongoing. Staff believes there is substantial evidence to support that as to the mold and the plants and bugs issues. And then for the storage in the garage, the original decision required the landlord to remediate the issue with haphazard storage of items in the garage. Tenants have stated that the issues are ongoing, and the city inspection found that there were items stored along the walls with photos provided. The landlord is arguing that they may not be able to contractually or legally ask the tenants to move those things because it may be part of their lease. However, that is not within staff's purview to provide legal advice to the landlord on how to comply with the original decision. The compliance determination decision found that that issue had not been remediated. Staff believes that there is substantial evidence in the record to support that decision, and therefore staff recommends that the commission affirm the hearing examiner's compliance determination in full. That concludes my report.
Okay, wonderful. Questions for council? I don't have any at this time. I think we're okay for the moment. So now we will move to the appeal portion. The landlord is the appellant this evening. Is it my understanding we do not have a representative, or do we? Mr. Ira Katz?
There's no representative.
No representative for the landlord tonight. Okay, so we can then move to the public comment portion, because that would be the interval, right? And we have two registered speaker request forms. We'll start with Mr. George Legrand, and then followed by Raphael, and I apologize for the last name, but Mr. Legrand, if you could start. And for both of you, you're going to get 3 minutes to speak, and that's it. You can only speak once. And what I would suggest to you, I said it in the other appeal, try to limit your comments to the 4 topics that we actually have, purview over this evening.
Is one of them public area cleanliness?
So the 4 topics are washer dryers, mold, plants and bugs, and storage belongings under stairs, garage, and common area.
Okay.
So those are the 4 areas that would help us the most if you can focus, but you get your 3 minutes and you can use it as you would like.
Okay.
And then you would state your name and city of residence, and you may begin.
Good evening, Commissioners. My name is George Stephen Legrand. I've been a resident of 917 Larrabee Street, apartment 19, since September 1st, 2009. I'm coming up on 16 years. I had actually hoped to go last in deference to Mary Kate and Raphael, who are our Tenants Association co-leads, and basically just to reiterate their comments and basically just to show up to offer my support to them. I'm going to keep this very brief because I can't specifically speak to any of those issues. I'd like to let them do that and give them the voice. But I just wanted to say that as I was preparing for tonight, I went through my file about this whole thing that's been going on for years, and I actually found the West Hollywood Municipal Code, which specifically states in chapter 19.30, property maintenance standards. All I'm going to say is I found 26 references that clearly violate what should have been caught and captured by anyone with a working knowledge of this code in the so-called inspection that this is referring to. So basically, that's all I have to say.
Okay. Thank you, Mr. Legrand. Appreciate
Thank you for your consideration and your time.
Yeah, thank you. Mr. Raphael? and I apologize, sir, I wasn't able to read your writing, but you tell me your name, city of residence, and same request as before: washer, dryers, mold, plants, bugs, and stored belongings under stairs, garage, or common area.
My name is Raphael Gamon, like come on with a G. Honorable members of the Mediation Board, esteemed lawyers and city officials, I'm speaking today on behalf of the Tenant Association of the library property. We seek justice and protection against ongoing negligence and harassment from our landlord. Earlier this year in March, a report was submitted by Ms. Gloria Aviles based on her inspection of our 917 Larrabee building on February 18th. Angie Ventura wrote this report. This sworn declaration was submitted to the court and was used to challenge the rightful decision for a $1,551.25 rent deduction you granted for our suffering tenants. The report not only falsely asserted ownership, but also glossed over grave issues such as non-functional washer and dryers, which are clearly mentioned in the D4877 list, point number 1. When guided to verify if these 6 dysfunctional machines in the laundry room had been replaced, her response reads, there are 3 washers and 3 dryers. The same broken units that catapulted the Rent Stabilization Commission to grant us a retroactive deduction of $492. Her misguided statement to court on behalf of West Hollywood contributed to ongoing oppression by landlord and failing system that should protect tenants. Please read her report on all points. Ms. Aviles, in her sworn declaration to the court, claims that Woody Porter is the owner, never as much as mentioning Mr. Soto introduced to her on 02/18/25 as the active manager. Woody Porter, Greg Segal, and his lawyer Ira Katz have been shown to submit falsified documents to the city rent ordinance and are known to have communicated multiple times without trace or records of their interactions, and to this day collude to confuse, mislead, and obfuscate responsibilities in this apartment building. $350,000 later, rent deduction. Most of the items are not fixed. A hire contractor expressed that there is no code officer in sane mind. He is hired by Greg Segal. In his professional career, he had never seen a re-roofing done so poorly. Mrs. Aviles thought it was done right. Systematic failures. We, the tenants, are trapped in a cycle of neglect and bureaucracy, where backdoor deals seem to overshadow our pleas. Our case of harassment and neglect have been repeatedly ignored, leaving us in a peculiar situation. It's baffling how the very individuals who should aid us and contribute to our struggle instead play against us. I'm asking you to give us guidance. I'm asking you to let us know how this rent deduction should be applied, because we did not receive any response to our plea on that. Thank you.
Thank you, Mr. Gamon. Okay, are there any other public speakers for this item? No, just those 2? Okay, great. So now we will go to Ms. Liebman, who's going to be joining us online. Ms. Liebman, you're going to have 5 minutes to speak however you would like, but you only get 1 opportunity because you're the respondent. And I'm going to give you the same request as before. If it's possible to please focus on the topics that are most germane to what this commission can do this evening: washer, dryers, mold, plants and bugs, stored belongings under stairs, garage, and common area. And with that, you can state your name, city of residence, and begin.
Thank you very much to the Commission for allowing me to speak and join remotely from the East Coast, where it is currently 11:40 p.m., so I'm going to keep my statements brief. My name is Mary Kate Liebman. I am the co-president of the Tenant Association, along with the previous speaker, Raphael Gamon, and I am the plaintiff in this matter. And I am speaking tonight to urge the Commission to follow staff's recommendation to reject another meritless appeal in its entirety. And I welcome staff to please refer to my comments submitted in June, which is a part of your packet this evening. I did want to add that over a year and a half after tenants first raised the issues outlined this evening, named in this complaint, the landlord has still taken nearly no effort to cure these issues and has instead, again, wasted everyone's time with another meritless appeal unsupported by facts or evidence. Funny, they should claim that in their own writing. In fact, in a sworn deposition taken only hours ago, Mr. Siegel, the registered landlord,
Hold on,
described the condition of our building as well cared for.
Miss Liebman,
Yes.
I do not think it's appropriate to be talking about deposition testimony that was just today before this commission. We can only evaluate the evidence that was submitted in connection with the compliance determination, and I'm really sensitive to that as a legal matter. So I would ask you please to focus on, you can talk about these issues all you want, but just focus on the evidence that was submitted previously in connection with the compliance determination, and do not speak of what happened today or what's happening ongoing in the litigation. Just the evidence for the compliance determination, please.
Understood. So I will just simply state that the reason I mentioned this is because regardless of when it was said today, or whether it was made in another meritless appeal in which the landlord has zero evidence to back up their claims to this commission, you have to understand that this landlord thinks everything is just fine at this property. No effort has been taken towards any of these issues to resolve them. And that is the reason why we are still here a year and a half later. That is the reason why this landlord has taken this city to court via a writ of mandate to try to get this thrown out, because he has no intention of fixing these things. And just like the case prior to ours, these landlords think they can just sit on a rent reduction and do nothing. The city needs to ensure compliance, and that if a rent reduction is not enough, please ask your code department why $0 in property maintenance fines have been issued at this property despite a record rent reduction. Your city needs to do more to help us. It's a shame that we have to take up time in further appeals and hearings. We would all very much like to move on with our lives, and I would very much like to go to bed. But yet here I am dealing with this again. And that concludes my statements.
Thank you very much for speaking tonight. And if you want, you can hang out and listen to the deliberation. At this point, I'm going to close the testimony part of the hearing. We don't have anyone from the landlord to rebut. We've done all the public speakers on this, so we can now do commission deliberation.
If we may ask a couple of questions I have for the...
Please,
yeah.
Commissioner
Thank you.
Topchin, lead us
Thank you,
in some
Chair.
questions.
Mr. Martz,
Oh, I'm sorry. Yeah, there were no questions for the tenant, correct?
Oh.
I apologize if I jumped to that. You have questions for council. Okay, great.
in regards to the washer and dryer, so this is a common area, right? So this
Yes.
$492 reduction applies to each and every unit?
That is correct.
Okay. And again, who has the ranges, the guidelines? I'm sorry I didn't get my packet today.
Yes.
How much?
But those were already pre-decided, right? I mean, we're not discussing.
That is.
No.
that
I'm
is-
just
Oh, okay.
I'm just asking questions, Commissioner.
Yes, the Commissioner Kripes is correct, but the common area washer is 30 to 84, and same for the dryer. And previously, the Commission had applied those correctly to each individual machine.
Right. I just wanted to, just out of curiosity.
Sure.
And my favorite question: do we know what's the tenant's current rent?
I don't, but these are common areas, so each of these items, and these staff reports, I know you had requested that, were submitted prior to your request, but those should be put in the upcoming staff reports.
Okay. All right. So, and the follow-up question. So the hearing decision was on the reduction in July of 2024, I believe, right? And the inspection date is February 10, 2025, which the inspection report shows that all washer and dryers were inspected and they're in good working condition. So how does this change anything if So the inspection report shows that the issues were based on the observation. The washer and dryers are in a good condition. So that, and you mentioned something about the examiner reviewing the inspection report, but can you repeat that statement? Your explanation?
Yes, so the landlord's appeal argument is that the inspection results were favorable to them, and so the landlord or the hearing examiner had to basically find in their favor. Okay. That's an incorrect interpretation. They may consider the inspection results, but it should be done in the totality of the evidence. And so here the hearing examiner had testimony as well that said they were not in working condition, and chose to believe that over the inspection results. And
okay.
So that's the discrepancy there.
Yeah, thank you so much. I wanted a clarification on that. Thank you. I appreciate it.
Of course.
Go ahead. Do you guys mind? Go ahead, Commissioner Kirby's. I feel bad you're so lonely over there on that side.
I remember this case previously with other issues. Some of these overlap. Can you give me a timeline to make sure that I'm understanding correctly what it is we're reviewing? Because maybe there are two reports, and I just looked that over, or overlooked that. But my recollection was that this is not a new this is not a new inspection, or is it? Has there been two inspections in this case? Because I do remember that the first inspection was that the washer and dryers were working the day of the inspection, but then the evidence was overwhelmingly that they work sometimes, but not all the time. They're not consistent. I remember that, and that's why the first hearing examiner, when it first came to us, why they took that into consideration but disregarded it. Has there been another inspection?
I'm going to look at the record, and I will let you know here shortly to explain the specific dates.
Because to me, it's clear that the washer and dryers, if the hearing examiner has found that the washer and dryers are not working based upon the evidence, I mean, I agree. I mean, there's no question in my mind. And not that it's relevant tonight. I mean, I was adamantly opposed, and I believe I voted against the commission's decision at that time because I think that the dollar amount is exorbitant, but for the washer and dryers that was given. But that's neither here nor there now because that has already been done and decided. And so what I'm understanding, what I'm looking at tonight is whether a new determination or compliance determination has been submitted and the hearing examiner reviewed those incidents and then determined that no, they have not been met. And that's what I'm think I'm deciding on tonight.
Yeah. Go ahead, Commissioner Copeland, while council looks into that.
But I have a question for counsel when he gets finished with that one. If I remember correctly, the hearing examiner said that the washers and dryers must be replaced, not just in good working order. Is that correct?
That is correct.
That was a specificity of that order. Okay, thank you.
I have a question for all the issues tonight: washer, dryers, mold and common, plants, bugs, storage in the garage. There were all previously rent reductions for those issues. Compliance, there was a compliance determination request, and they were effectively denied as to all those issues, meaning essentially, no, those are still ongoing issues. It hasn't been complied with, so the previous rent reductions would continue to be in effect. That's for all four of these items tonight, if I understand that correct. So if we affirm, we're effectively saying there wasn't compliance on these issues. We think that the evidence was properly reviewed, and we're affirming the continuation of the rent reduction on these four items as in the amounts that were already determined, which we're not touching tonight. But that's kind of the scope of where we're at, right? I mean, for me, I would have no reason. The landlord didn't show up. We didn't hear anything to the contrary this evening. The staff report I thought was pretty thorough. We heard an impassioned plea from the tenant who's obviously still going through all of this. So I'm very much in favor of affirming the recommendation and adopting the resolution in full. And if others have different thoughts on modifying it or in some way, let me know, but that's where I'm at.
And I have the answer if you're ready for it. Yes, there was a request from the hearing examiner to go out and do an inspection as part of the compliance determination request. And so that is what is in your packet. And that was done in February.
That would have been after the...
There's only been one, I believe.
We've already hashed out whether, I mean, to me, that's not an issue anymore, right? I mean, that was an old, why am I confusing this case?
We approved the rent reductions in November, and then a compliance determination got submitted afterwards. There was obviously some sort of inspection in February. They denied the compliance determination. The landlords appealed.
We haven't seen it in that time.
And we haven't seen it since November, no.
So there must have been an inspection in the very first hearing as well. No?
No, because Gloria, the acting manager, would have been either the one doing it or been involved in that process. And yeah, this is the only inspection.
That's the only inspection.
So you might have
that was in
heard
February.
testimony, or you might have had something submitted by the tenants that you read that spoke to that issue. I don't know. Or it could have been the technicians. I know there's been technicians that have gone out there and they've submitted information, but here the decision was from last year, and this inspection by staff was on the 10th of February 2025, and it was as a result of the compliance determination request from the landlord.
Okay.
Vice Chair?
So given what we're looking at here, I'm also prepared to affirm. The staff report said that there wasn't really evidence that the landlord is submitting to say that these things have been complied with, and the landlord also is not here to speak to it. So I'm prepared to go with staff's recommendation.
Commissioner Topchin, are you?
Yeah, Chair, thank you. I'm in agreement with the staff's recommendation and will affirm the findings. Thank you.
Commissioner Copeland?
Same. Thank you, Chair.
Commissioner Kerpes?
Same.
Okay. So then at this point, I will make a motion to adopt and affirm in full resolution number 25-687, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's compliance determination as to application number D-4877CD1. And with that, if the parties have, do we have a second on that?
Second, Chair.
Okay, and let's do a roll call on this, please.
Commissioner Copeland?
Aye.
Commissioner Kerpes?
Aye.
Commissioner Topchin?
Aye.
Vice Chair Rory? Vice Chair Goldman?
Aye.
Chair Rory?
Aye. All right, so with that, that motion passes 5-0. If the parties have any further questions, you can reach out to the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. And I don't know if Ms. Liebman is still on Zoom, but at this point, this portion of the appeal is concluded, and you can watch the rest of the meeting at weho.org/WehoTV. Okay, so that completes the appeal portion. We can now move on to new and unfinished business. We don't have any here. And then we can do items from staff.
Good evening. I do have a few things. One, I'd like to let you guys know that the newsletter, the summer 2025 newsletter, is ready to be mailed out. It's being distributed early next week. So tenants and landlords will be receiving them in their homes midweek next week. It does include the 30-day notice to increase the rent, and it's also available on our website. The security deposit interest accrual calculation meeting for August 14th, where we're requesting community input, has also been announced in the newsletter, and my understanding is that we also provided a press release tonight for the community members to be aware of this meeting that's going to occur on the 14th, and lets them know that it's going to be here. If they can attend in person, they can come in through a Zoom meeting, or they can put in a comment by noon on that day. The Valuation Ad Hoc Committee, I will be sending an email before the end of this week, just reminding members we will be coordinating a meeting next week, just finding out their availability so that we can develop a work plan outlining the committee's objectives and strategies for achieving them. I did want to also report the eviction notices and the BITSETIC eviction assistance numbers. I know you've been requesting that, Chair Rory. So I will try and give this to you on a quarterly basis so that we are able to get those numbers from BITSETIC. We are keeping numbers internally as we receive copies of 3-day notices as well as summons of complaints. So I'll give you those numbers first. For the second quarter, which would be April through June, we received 187 3-day notices for non-payment, 28 notices for 3-day notices for curing the covenant, and 52 summons and complaints. BITSETIC is reporting that between January 1st and July 24th, 199 households actually contacted them through the West Hollywood email inbox. They attended Plumber Park clinics, or they called the West Hollywood dedicated hotline. Of those 199, 133 resulted in cases opened as eviction cases. BITSETIC represented 41 of those cases in court on eviction proceedings. 89 cases have been closed, 32 cases remain open. Commissioner Goldman received an email from a tenant this week, and she felt that it was important that we share the information here, since this may be something that a lot of tenants in the city are experiencing. The tenant reached out to us asking, apparently the building is recently noticed the tenants that the property is transitioning to an online rent payment system, and he noted that there were fees being applied for each payment method ranging from $2.49 to $9.99. West Hollywood Municipal Code Section 17.32030 clearly defines the types of miscellaneous fees a landlord is permitted to charge a tenant. The fees mentioned in this tenant's email does not fall within the allowable categories outlined in this section of the municipal code. Additionally, California Civil Code Section 1947.3 prohibits landlords from requiring tenants to pay rent exclusively through electronic funds transfer, otherwise known as EFT. Landlords must offer at least one alternative payment method that does not involve EFT. Tenants can continue paying their rent using the same method they used prior to the introduction of the online payment portal. If the landlord refuses to accept your rent using that method, please contact us at 323-848-6450 or email us at rsd@weho.org. Additionally, you may file for a rent decrease hearing for the removal of a housing service, and if any illegal fees were charged, the landlord may be required to issue a refund in accordance with the rent stabilization ordinance. In the same email, apparently several tenants have not received the required annual interest on their security deposits as mandated by West Hollywood Municipal Code 17.32020, subsection 4. Just a friendly reminder, every winter, sometime between December and early January, tenants are notified of the annual security deposit interest rate through the division's newsletter. So please be on the lookout Landlords are required to pay this interest by January 31st of each year. If the landlord fails to make this payment, the tenant is permitted to deduct the interest amount from their rent beginning February 1st or any month within that calendar year. State law provides a 3-year statute of limitations for unpaid interest. To recover interest owed beyond the applicable calendar year, tenants must file a claim against the landlord in small claims court. Please keep in mind that there was 0 interest on security deposits between the years 2012 and 2021. And just also, if you want to initiate a formal code inspection for your unit or building, tenants can submit a complaint through the city's Neighborhood and Business Safety Division, also known as Code Enforcement, by calling their hotline at 323-848-6516 or by emailing them at code@weho.org. Those were all my announcements.
That was great. That was very helpful. Do you have, it looks like Commissioner Topshin might have a follow-up.
Yes, good evening, Manager Aviles. Can you repeat that Muni Code section number regarding the online payment fees?
Yes, so the miscellaneous fees are under section 17.32.030 of the municipal code.
Thank you.
Okay, great. If there are no other follow-up questions, we can move on to item 12, which is items from commissioners. I'll just start real quick and then kick it down the line. Thank you for those stats tonight on the evictions. That's great, and quarterly would be wonderful. Reporting on that, I think they really give a pretty robust picture of how much West Hollywood does through BetCedec and its other services to help, and what kind of a volume of need there is. So that's very enlightening to hear about. I thought that you probably already made the note, but for the ad hoc committee, we should look into the mold mildew stuff and the ranges for that. That was obviously an issue that came up tonight that might be germane for that ad hoc, so to confirm that. And just to say how much I appreciate all the hard work that staff puts into not just the appeals tonight, but every appeal. And I don't think that gets spoken enough about. So I see it and I appreciate it. I know my fellow commissioners do too. Commissioner Copeland, do you have any comments or?
Other than to echo what you just said, to thank staff. They've been very helpful as always, and whether they are fully staffed or shorthanded, they still continue to provide everything to us that we need to continue our work here, and it's very much appreciated. Thank you.
Commissioner Topchin.
Oh, thank you. Just echo my fellow commissioners. Thank you, staff, and especially the legal counsel's excellent reports this night. Very helpful. Thank you.
Vice Chair.
So I want to thank Manager Aviles for not only answering that community member's question and email, but also upon request reciting that, because I know people watching this, we hear it a lot, but I think it's so important to repeat it because people might be hearing things for the first time. So thank you so much for those thorough answers and for also saying all that on the record here.
Commissioner Kerpes, close this out.
Thank you. I was just going to say thank you for all the information on the interest, or all the efforts that's going into the interest rate discussion for doing the press release and everything. But then you went on to continue to talk about great things. So I think we should just take a little video of that, maybe with some music in the background, a disco ball, and ship it out so everyone can learn all these interesting things and all the protections that they have. But thank you for all the work that you guys are doing.
Okay, great. So,
congratulations to our chair for a first meeting and getting us through those two very long, especially the first one.
I appreciate it. Thank you for holding down that side of the dais, and we will get better at this as we move forward. And so with that, I will adjourn tonight's meeting to the next regularly scheduled meeting of the Rent Stabilization Commission to be held on August 14th, 2025 in West Hollywood Park, Public Meeting Room, Council Chambers. Thank you all for coming and watching.